All right, so we're moving into our civil rights topic. We've dealt with civil liberties, which are protections from the government, and civil rights are protections by the government. And so we're going to look at this a little bit more in depth, and we are going to talk about the fight for civil rights that has been in effect in America since essentially its inception. And so, if we look a little bit at the history of the civil rights movement, which really took hold after the Civil War and the passage of the 14th Amendment, all the way up into modern day, we do have the passage of that 14th Amendment in 1868, which we've referred to already in our civil liberties topic. But it says, no state shall protect or enforce any law which shall deny to any persons within its jurisdiction the equal protection of the laws. And as I said before, it essentially gives the appearance of an equal society, but the Supreme Court wasn't really prepared to enforce this amendment once it was adopted. And Congress will pass the Civil Rights Act of 1875, which attempted to protect blacks from discrimination by hotels, theaters, and other public accommodations, but the Supreme Court will actually declare the Civil Rights Act of 1875 unconstitutional because it sought to protect blacks from private businesses. The Supreme Court said that the 14th Amendment was intended to protect blacks from public officials and not private businesses. So they struck down the Civil Rights Act of 1875, and it's going to touch off roughly a 100-year period where there is only incremental success in the civil rights area, and we have a Supreme Court that is going to be very hesitant to incorporate this idea to the different states. And so we're going to look at an overview. Understand that this is not going to be an exhaustive look at the fight for civil rights because that would take an entire course. But we're going to look at an overview of the fight for civil rights. And we're going to begin with the idea of separate versus equal, or separate but equal. And this was decided in a Supreme Court case known as Plessy versus Ferguson, which has been a stain on American history since its inception in 1896. And so we'll look at Plessy versus Ferguson in just a moment. All right, so Plessy versus Ferguson. As I said, it's a real stain on history. Louisiana had a statute requiring segregation on trolleys and other forms of public transportation. And an individual named Homer Plessy will violate this law of separate but equal accommodations, and he is fined $25, which doesn't seem like much, but in 1896 it was the equivalent of about $730 in today's money. And so it's going to work its way all the way up to the Supreme Court, and the Supreme Court will uphold Louisiana statute that says segregation is okay so long as the accommodations for whites and blacks are equal. Well, we know darn well that that is not going to be the case, and but this will be the prevailing policy Supreme Court decision for the next 50 or so years, 60 years. And so it's solidified the separate but equal rule that lasts up until about the mid-20th century. One of the biggest fights for civil rights took place in education. And one of the places that it took place is going to be Missouri. By 1938, Missouri had a law providing tuition money for qualified blacks if they would attend out-of-state law schools rather than admitting them into the University of Missouri Law School. And so they were saying, you may be qualified, but we don't really want you to go to our law school, but we'll give you money if you go to a law school out of state. And so it sends qualified individuals to another state to pursue their law degree. Let me qualify that. Black individuals. The court is going to come down on this and rule that it is unconstitutional. So we start to chip away a little bit at some of the civil rights. It's very small incremental changes. It doesn't occur very quickly and it doesn't occur overnight. Then you have Brown versus the Board of Education, which is sort of that landmark idea, that landmark Supreme Court case that helps to move towards integration of the public school system. Now, there were multiple suits filed in 1952 regarding segregated schools, one in D.C., one in Delaware, one in Kansas, South Carolina, and Virginia. But the court decided to take up the Kansas case because it had gone farther along in the district courts and it was not located in the Deep South. And so their strategy was, if we can get this applied in an area that is not the Deep South, then maybe it won't be such a blow to some of these deep Southerners. The Brown versus Board of Education case will stem from an incident with Oliver Brown and his child, Linda Brown. Linda had to walk a mile in dangerous neighborhoods to a bus stop in order to be bused across town to the school for black children, although the white school was much closer, and so she was putting herself in danger every day just trying to get to the bus stop. Oliver Brown decided to take Linda to the all-white school to enroll her into 3rd grade, even though it was against the law. The school will refuse, and Brown will take his case to the NAACP. Soon after, the Brown versus Board of Education case will be born. In 1954, the Supreme Court will rule that states no longer have the power to use race as a criterion of discrimination in law. Second, the national government from then on had the power and obligation to intervene with strict regulatory policies against the discriminatory actions of state and local governments, school boards, employers, and many others. So what this case does is it overturns separate but equal, because it says states no longer may use race as a criterion for deciding what child goes to what school. And it says furthermore, if you don't like that, the federal government is going to be overseeing this. We're going to step in as necessary. Now, it's a big step, but even 10 years after the case, fewer than 1% of schools were integrated. And so it's going to take a lot of pushing and pulling and the stepping in of the federal government to actually get schools integrated after this case is decided in 1954, but it is a huge step because it does overturn the prevailing policy of separate but equal in Plessy versus Ferguson. And so the civil rights movement is really going to grow out of some of these early cases. And Congress will have to step in and remedy the issues associated with racism and segregated society. They can no longer rely on states to do what is right, and they will now step in and remedy any of these issues, if necessary. So we have the Civil Rights Act of 1964 that's going to deal with public integration. Signs denoting white and colored accommodations are going to be removed from restrooms, water fountains, waiting rooms, and seating arrangements. The federal government will file more than 400 anti-discrimination suits in federal court against hotels, restaurants, waiting rooms, and seating arrangements. So we see that this is a departure from Plessy versus Ferguson. This is a departure from, well, Plessy, yes, but that Civil Rights Act of 1875 that was struck down by the Supreme Court because it dealt with private versus public entities. And so we have some movement, but there's still much to do, and it's by no means over. School desegregation, the Civil Rights Act of 1964 also was going to create what is known as what will be administrative agencies to help implement new anti-discrimination laws. They will also step in with employment practices, and the Civil Rights Act of 1964 will outlaw job discrimination by all private and public employers that employed 15 or more workers. And so the government kind of put some teeth into this by revoking public contracts for goods and services to companies that did not abide by these new employment guidelines and practices. And so there's going to be different areas of the fight for civil rights in education, in public, in voting. Voting is going to be a huge area of civil rights. The Voting Rights Act of 1965 barred literacy exams and other tests as a condition for voting in 6 southern states. So some of these barriers that were put into place that were really stacked against African Americans and poor people were removed, and so they could not create literacy exams. Previously, the 24th Amendment had been passed in 1964 that outlawed the abolishment of poll tax, so it's going to provide access to the voting booth to many more people. It also provided for federally appointed registrars to replace state and local registrars if there was an intervention in voting. So if state and local registrars didn't allow people to register to vote and exercise their right to vote, the federal government would step in and replace them with a federal employee. 1964 also mandated that bilingual ballots or oral assistance for speakers of Spanish, Chinese, Japanese, Korean, and Native American languages be offered. And the voter rights concerns, there were voter rights concerns because of voter right ID laws in modern day. So we're still dealing with some of these civil rights ideas in regards to voting, because we're looking at these ID laws that are being put into place by different states, and they're tied up in the courts, and the courts are saying yes, they're okay, or no, they're not okay, and so we still haven't seen all of the barriers removed from individuals participating in the right to vote. Housing was an area that the civil rights movement was fought in as well. And the Fair Housing Act of 1968 was passed, which outlawed housing discrimination and the sale or rental of most houses, eventually covering nearly all of the nation's housings. But to begin with, the mechanisms are going to be very weak in the Fair Housing Act. Individuals are going to be the ones that have to prove the discrimination, and that's sometimes hard to do. So the burden of proof is going to be placed on the individual who is making the accusations instead of the individual who's being accused of discrimination. And so these procedures, even though it was passed in 68, are not going to be altered until 1988 with the creation of the Department of Housing and Urban Development. And what we have to understand is that the Civil Rights Act, even though it is typically thought of to be an African American issue, it's for any disadvantaged group. And there are a bunch of different disadvantaged groups that have fought for equality in America over time. One of those groups is women. Women didn't even have the right to vote until the passage of the 19th Amendment in 1920. The National Organization of Women picketed against sexist employment practices. Women's Equality Equity Action League pursued legal actions against law schools and medical schools for discriminatory admissions policies. Activists sought to add an Equal Rights Amendment to the Constitution. And in short, it said, equality of rights under the law shall not be abridged by the United States or any state on account of sex. And so this Equal Rights Amendment was really something championed in the 1970s, and it was very easily passed by Congress in 1972, but fell 3 states short of the 38 states necessary to ratify the constitutional amendment. And so it didn't pass. It is not a constitutional thing, constitutionally protected right, essentially, but the Supreme Court has helped to establish some gender discrimination, has helped to establish gender discrimination as a big civil rights issue. And so while it does not treat it as the same, it doesn't treat it the same as it does racial discrimination, it does make it easier for plaintiffs to file and win suits on the basis of gender discrimination. You may have heard of a thing called Title IX, and this is of the 1972 Education Act. It forbade gender discrimination in education, but it initially sparked little litigation because of its weak enforcement provisions. And so in 1992, the court decision, a Supreme Court decision deemed that monetary damages could be awarded for gender discrimination. And so it opens the door for more legal action in the education arena. typically in the areas of sexual harassment and women's athletic programs. In 1996, the court put an end to all male schools supported by public funds. And then we have what is known as the Lilly Ledbetter Act that was passed by President Obama in 2009. Lilly Ledbetter was a worker who found that she had been paid 40% less than her male counterpart. She sued because she was paid less, but was denied claim by Supreme Court because workers must file a grievance 180 days after the discrimination occurs. And this had been an ongoing thing for a very long time. And so she didn't file within the statutes of limitations, and so the Supreme Court denied her under the law. So President Obama signed the Lilly Ledbetter Fair Pay Act, giving workers expanded rights to sue in cases such as Lilly Ledbetter's. And so essentially it eliminates the statutes of limitations and allows them more rights to sue for these cases. Another area of civil rights disadvantaged groups trying to receive equality are Latinos and Asian Americans. Limited English proficiency hindered some Latinos and Asians from participating in American life. But the Supreme Court has stepped in and tried to rule in cases to assist in this. And in 1974, the Supreme Court ruled that schools had to provide education to students so that the students could understand it. Meaning, it doesn't have to be in a bilingual setting, but it must accommodate their limited English proficiency. So yes, you can teach them English, but you must accommodate that. They're not going to be fluent in English immediately, so you have to scaffold them as necessary so that they can understand what you are teaching them from the time they begin learning until they become English proficient. We've already talked about the abolishment of the literacy tests and the mandating of providing ballots in other languages, and there are still significant issues associated with these groups today, and they have by no means received, none of these groups have really received full equality, so there are still significant issues that are at play that are being fought in the world today. Native Americans, in 1975, Congress established the Native Americans be taught in their own languages, and they began suing for sovereign status within the U.S. This has allowed Native Americans to become much more self-determinant. Because they are recognized as their own sovereign nation within their reservations, their areas that they are living on, they can sort of circumvent some of the laws of America because they're sovereign countries, essentially. And so in 1987, a court decision will free most Native American tribes from state regulations that prohibited gambling. And so that's why there is gambling on some of these Native American casinos, because they do not necessarily have to follow all the same laws that other Americans do, because they are essentially their own sovereign nation. Disabled Americans are a group of disadvantaged individuals. In 1973, the Rehabilitation Act outlawed discrimination on the basis of disability. In 1990, the Disabilities Act guaranteed equal employment rights and access to public businesses for the disabled and barred discrimination in employment, housing, and healthcare. So you cannot be discriminated against just because you have some kind of a disability. And there are actually, in the education arena, I know, there are certain laws that protect you. And if you have a disability and is documented and you have reached out to the college, we as professors must accommodate you to the best of our abilities. Another group that are disadvantaged are gay and lesbian. Gay rights has become one of the largest civil rights movements in modern America, in contemporary history. America's history regarding gay rights, it has changed significantly over time because, to begin with, individuals were regarded as sexual deviants, and states criminalized sexual acts, and it was even seen as a psychological disorder. In 1986, the first Supreme Court case on gay rights ruled against a right to privacy that would protect consensual homosexual activity. And so it doesn't do a whole lot for this disadvantaged group, but there is going to be incremental progress that will be made. In 1996, the Supreme Court struck down a Colorado state constitutional amendment that banned local governments from passing ordinances that protected gays and lesbians. So certain cities were passing ordinances that protected gays and lesbians. The state of Colorado stepped in and banned local governments from doing this. And then the Supreme Court stepped in and banned the state of Colorado from banning these local ordinances. And so it's kind of a step in the right direction for these disadvantaged groups. In this 1996 decision, the courts will equate gay rights as civil rights. In 2003, a Supreme Court case overturned that 1986 case and struck down a Texas law that made certain sexual conduct between consenting partners of the same sex illegal. So it essentially struck down laws that made homosexual acts a crime. And remember, in 1986, the Supreme Court has essentially done just that. Now, it did not change federal and state laws that deprived gay people of full civil rights, including the right to marry, but it did strike down laws that essentially criminalized homosexual activity. In 2013, the Supreme Court struck down the Defense of Marriage Act that barred benefits to same-sex couples and allowed California laws to recognize same-sex marriage. And then, of course, in 2015, on Obergefell v. Hodges, the Supreme Court ruled that the Constitution's Equal Protection Clause of the 14th Amendment guaranteed same-sex couples the right to marry in all states and required states to recognize such marriages performed in other jurisdictions. And so the Supreme Court is going to kind of put I hate to say an end to, because it's not, I don't know that it really put an end to, but it really incorporates the ability of gays and lesbians to marry in all states, because it had been legal in Massachusetts and Hawaii and California, but it had been illegal in places like Texas and Alabama and Mississippi in the Deep South. And so if a gay couple were married legally in California, but they had to move to Texas for, say, a job, their marriage was called into question. And so the Supreme Court steps in and sort of attempts to make things more equal across the states. And Texas had on the books a state constitutional amendment passed in 2005 that outlawed gay marriage. Well, that was struck down with this Obergefell versus Hodges in 2015. And so this is the conclusion of our Civil Liberties and Civil Rights unit, or the lectures for it. Go ahead and move on to the assignments that are associated with this. Understand that a lot of the civil liberties and civil rights are going to be connected to Supreme Court decisions, and that's what we're going to be looking at as we move forward.